So cool though.
It's very cool. Yeah. So everybody can hear me, can see me. So yeah, cool. It's nice to have some people here tonight for another topic that we are presenting with Crypto World Zug tonight. So we have Chris and Peter here from Baker McKenzie, as you can see on the screen. And they're going to give us a little bit of an update on the status of ICOs and maybe STOs, we'll see. And they're going to do it again, but I've always wanted to say this. This is not investment advice. Do your own diligence, do your own research, right? So we all know that by now. But I've always wanted to feel like a real YouTuber. So you guys, I'll give the hand off the mic and
go for it. Thanks for coming, everyone. I'm Chris Murrer, as Bart mentioned, and this is my colleague Peter Mitchell. We work with Baker McKenzie. This is meant to be an informal discussion. This is a meetup after all. So Peter and I very easily can give a presentation reciting rules and talking about nuances for hours. But that's not really that fun, and I don't think it's really what the spirit of this event's about. So feel free to interrupt us, have a conversation. We can maybe reel it in if we need to, but we're going to get through as much or as little as of this presentation as we can. A lot of that just depends on where the interest lies. And with that, what we want to talk about is the current status of the token market, where it came from, what it is today, and where we see it going in the future. And so if we just think, and I'm going to turn it over, sorry. So we just think about we're going to first just go through the trends just to kind of set the stage for where we are. And I think hopefully that kind of gears our mind to where we should be looking to in the future. And I'm going to turn it over to Peter for what he came up with last night.
All right, so Chris didn't stop me when I threw this in the slide deck, so you can blame him. I know this is corny, but this presentation is brought to you today by the number 195. In the US, there's a show called Sesame Street, and they always start off with, this episode is brought to you by the color purple, or something stupid like that. So when I was in law school, they always told me, when you're talking to a jury, and tonight you're my jury, let's be real about that, you leave them with something a little bit mysterious in the beginning. You don't quite know what it means, and then by the end, hopefully, it'll make sense and tie the presentation together. So this is our intro. It's a little bit mysterious, and hopefully by the end, we can shed some light on that.
So this next slide is something that we were using earlier in the year. And actually, when we first started giving these presentations, it was around December or January. And as you can see, this is the total volume globally of capital raised through ICOs. And this was just real fun to show the audience. When we were in December or January, that looked great, and everyone was really excited. And we heard from so many people who had so many exciting projects. And then 2018 started, and we started to get into March and April, and we had to update the slide a little bit, and the numbers dropped off. And so this is the slide we were using at the beginning of the year. And our question was, are ICOs the next big thing? Was it a bubble? Was December and January just kind of anomaly, and we're back to the status quo? If you take out December and January, the line's actually pretty stable. That's not a bad thing. And then if I'm going to ask Peter to go to the next slide, this is what the rest of the year looked like. So if you remember, this is the same scale that we had on the last slide, but this is from April this year to November. And depending on where you check, we're down from 90 to 94% of where we were earlier this year. And that's really caused a lot of people to pause. And you can wonder if, since we're in a bear market now, is the trend over? Is the dream dead? Is the idea that everyone could raise capital or start their project in a really interesting way, they didn't have to go through the really expensive process they did before? Or are we really just in a new and different era where, let's be honest, maybe the not so good projects have kind of gone by the wayside? People have figured out that if it's not a good project, this isn't the way to raise money anyways. And what we're left with are the good projects still. And so that's what we kind of want to talk about, and whether there's a way to set up your project now if it is one of the good ones that remains so it succeeds in the future. And again, feel free to jump in and let me know, because a lot of you guys I know are in the trenches. You're developing this stuff. You're trading day to day. You're setting up these platforms, so we want to hear from you too. And so if we think about just two general categories of how tokens are given to the public, we have the ICO, or the token generating event. This is just where the project either hasn't started, the company wants to raise capital, so they say, once our platform is up, we're going to give you tokens, or our tokens are ready, and if you give us capital, we'll give you tokens. Or there's the airdrop, where the token exists, and the idea is that they just give them away for free, quote unquote. And my colleagues and I talk about, is there really ever a gift that falls from the heavens into your wallet? And that's really the question of how we think about these in regulatory speak. But these airdrops happen either on one of two situations generally. Either they're sent to everyone that's in a network. So if you're on the Ethereum network, you get tokens. Or if you are actually on a more defined platform that is already using those tokens, maybe you get some free tokens additionally. And the way we typically talk about tokens is they fall in one of three buckets. So we have the payment token. This is what you're thinking of the traditional way. So it's Bitcoin. This is Ether to a certain extent. These are tokens that you use basically to buy goods or services. They may be generally, you're supposed to be able to buy goods and services from any provider, or it's a specific provider. Then we have what people like to refer to as the utility token or the access token. This is a token you use to access a platform. And this is the one that was really popular in 2017. This one is not supposed to be a security, right? It's just supposed to allow you to use something. It's like a good or a service. And then we have an asset token, which represents or is backed by some sort of asset or interest in the company. So this is where it starts sounding a little bit like stock, or it's representing an interest in property. So this could be interest in a company itself, or maybe it's an interest in a car or real estate.
Right. And so I think that that's a good place to talk about a security token a little bit too. So is there a real difference between a security token and an asset token? And right now, I think from a legal perspective, one of the main differences is that we've seen is with an asset token, you have something that isn't necessarily calling itself like a security. With the security token, you do. So a security token, they want to create something that entitles you to, investor protection. So is the board of this company running this in a terrible way? Can you sue to make sure that that the company is being run right, or that the token or whatever is being managed correctly? That's something that a security token could potentially offer you. Security token offers you the same kinds of rights that an investor would have in investing in a company. An asset token might not offer you that. The asset token might give you something that's tied to the value of an asset, but it may not give you the same rights that an investor in a company would have. So that's one of the potential differences between a security token and an asset token. But I would, go ahead.
Would you then actually create a fourth bucket?
You might see a fourth bucket. There's, I think, a distinction to be made in this asset token category. I think that that's going to be borne out by the courts. Is a court of law, it's not answered yet. Is a court of law going to take somebody who has an asset token, but perhaps not a full-on security like a share, and allow that person with an asset token to enforce rights, the same rights that a security holder would have? In the United States right now, there's a lot of lawsuits right now that might touch on that. So that's why there is potentially a difference between a security token and an asset token. And those rights and distinctions are still being defined. So I think you could in the future see even a fourth category for security tokens.
And I think at best right now we're calling them hybrid tokens, or it's something that may share one or two or three of these categories. And as Pierre is saying, maybe we just have another definition down the line. But I think at best, if it has some semblance of a security token, that's the default for the government.
So, and also to note, just before we move on, is even if there are two different categories here between a security token and an asset token, from a compliance perspective, at least from U.S. law, there's not going to be a real difference in securities law compliance between a securities token and your asset token. So both are going, from at least the U.S. perspective, if you're offering a security token or an asset-backed token, you're still going to have to meet either the registration requirement or an exemption to the registration requirement, right. Which is something we're going to talk about a little bit more.
all tokens are going to be considered security tokens?
Yeah, absolutely.
Right.
So the Chairman Clayton did make a comment that he hasn't seen an ICO that hasn't looked like a security. He's backed off that a bit, but we're going to touch on that a bit later too. So
these aren't.
we'll cover that in a
sorry,
moment.
just to make sure I'm clear. I'm being clear about this. This are not legal classifications. This is just kind of descriptors.
And these vary from country to country too. This is currently the Swiss model. They make comments about hybrid tokens too, which isn't on here. But in the US, this doesn't really exist. The concepts exist. People argue them in courts. But they haven't set out a framework like this yet. So this varies from country to country.
Which ones make you be accredited and which ones don't? Or they just all?
In the US, you're going to have to comply with securities regulations for all of them, probably. Now for Bitcoin and Ethereum, I have a bit of a...
Yeah, we'll come up. There's a slide where we have some of the quotes that have been said publicly.
So
we can, again, we don't want to crowd everyone with just the rules, but Switzerland doesn't have any strict laws on this, but they've issued guidance that have helped people kind of work through these issues. And so what they've said is that a payment token and a utility token don't necessarily qualify as securities in Switzerland. And that's good. They're seen more as either a currency or a good or service. If something is an asset token, though, it constitutes a security and you have to go through all the processes in Switzerland. If your token is any of these, but it's pre-sale, so it doesn't yet exist, and you're trying to raise money for it, that's considered a security in Switzerland. So even if what you're going to issue later is a payment token, if you're raising money before it's functional, it's a security in Switzerland. That being said, if you plan ahead, we really feel like Switzerland is a pretty accommodating and friendly jurisdiction for this. And we're going to compare that to the US in a second. And so, Peter, do you want to talk about the Howey test?
Yeah, sure. So the Howey test is an investment of money in a common enterprise with a reasonable expectation of profits to be derived from the entrepreneurial or managerial efforts of others. It's really broad, and that's on purpose. If you have an investment of money with a reasonable expectation of profits, which is what a lot of people were doing over the last couple of years, then potentially that's falling under the Howey test. You have to take it token by token, and it's full facts and circumstances type of analysis. But this is a test that could affect a lot of different tokens in the United States of America.
And just, sorry to interrupt, just to give you a background with how broad this is, this test came from a case where someone was offering investment contracts to Northerners coming down to Florida for investing in his orange groves. So this wasn't even interest in a company. What this person was doing is saying, if you invest in my orange groves, I'll give you a part of the profits. And so it wasn't even an interest, a stock in the way that we typically think about that.
Right.
And so I think that's important to think about when you're trying to reconcile the idea that the U.S. treats this so broadly. It had to do with orange juice, basically.
And they were even in that case selling title to plots of land and saying what you're buying is a plot of land. And they had a title to show, but what they were really doing was investing in an orange juice business. So even though what they were doing was buying land on paper, the government said, no, this is actually security. Even though you call it a sale of land, it's actually security. So the U.S. government has no problem coming in after the fact and saying what it thinks is actually going on in those circumstances. So how do you deal with this? So the example that Chris gives is an investment contract. And at this point, when you have a lot of pre-functional tokens, you have what may look like an investment contract. And so how do you deal with that from a compliance perspective in the U.S.? So have a lot of you heard of the SAFT? Yeah, sure. So probably most people are a bit familiar with the SAFT. It's probably at least the most famous method right now of raising funds in the U.S. and trying to do it in a compliant way. It was at least initially billed as sort of a pretty safe way to do it. That's come under more scrutiny over the last half a year, especially. And it's something that now I think a lot of law firms are actually backing away from, especially for certain deals. I mean, it may work. It's something you also have to take case by case. It may work in a few circumstances or for a few tokens, but it's not going to work for all of them. What the SAF basically is trying to do is you have what's called a private placement memorandum in the US, usually under Regulation D. And you complete this, and it is basically a prospectus for your investors that tells them about the investment and informs them about it. And you use that to raise initial funds. And then when your token is functional, you can have a functional, for example, utility token that might not be a security. I think is sort of the basic framework behind that. I don't know if you have anything else.
So the idea is it's initially a security. What you're offering is an investment in your platform, and then once you have the platform up and running, the tokens they're more like a good. This is the idea behind it.
Right.
What are they doing with I read some articles about tokenizing real estate in New York. Would that fall under that? Because that's
So the SAFT, and Pierre can correct me if I'm misstating this. The SAF works if what you're ultimately going to be presenting when the token is functional doesn't sound like it's an investment contract or it's not a security anymore. And so what you're trying to offer is maybe a payment token or a utility token. And so what you're describing sounds more like an investment in real estate just through a token. So you're tokenizing an interest in real estate, which probably is going to be considered a security regardless.
Right.
Yeah.
So, and that's a good example to talk about a different strategy for complying with U.S. law, which is when you have something on the second phase. So in the first phase, you have something like an investment contract. It's pre-functional, and you comply with securities regulations by complying with Regulation D or Regulation S. That's phase one. Phase two was there's a utility token. Maybe you don't need to do anything. But if you have like an asset-backed token, for example, you might have to do it all over again. So, or if you have a utility token that you can't guarantee is a utility token, or you don't think it's functional enough or decentralized enough, you do another Regulation D. So you do a Regulation D in the beginning, you do a Regulation D again. So you have to do a Regulation D twice. And Chris and I affectionately call that the double D. Double Ds are good. So if you want to be compliant with U.S. law, you need double Ds. That is, so that's U.S. compliance in a nutshell, I think.
And so, fortunately, we have people that are very astute. We just have the quotes that were kind of touched upon. So initially, this is, as early as February and April this year, every ICO is offering securities, and the ICO market is what the securities market would look like if we weren't doing our job. And then we compare that to June, where they're looking at Bitcoin and Ethereum specifically, and they're saying, well, maybe those type of platforms and those tokens are not offering securities. And the question is, would those have been securities at their initial offering? So when Ether had their ICO, or Ethereum had their ICO, was that a security? They didn't really say, but they're saying now maybe not. And so the idea is if it's sufficiently decentralized and it looks like an Ether at this time, maybe it's not a security anymore. And so the idea is that these things can evolve over time. We also want to just touch upon the Communities Future Trading Commission has also exercised jurisdiction over these tokens. And again, that's because their jurisdiction's really broad. So they have jurisdiction over agricultural commodities and all other goods and articles except onions. And I don't know what the onion lobby did to get that exception, but that's in the statute. Yeah, exactly. Maybe that was it. The CFTC just didn't like crying. And so you may have concurrent jurisdictions with the SEC, the securities regulator, and the CFTC for commodities at the same time, or you may transition from a security to a commodity. And that's just something to keep in mind. But if you are someone who's a fund manager, if you're going to broker these tokens, you may have to register with this commission. And that's just going to, I think, really trip people up because they're not thinking about it. And so with that background, where do we go from here?
So we just wanted to take this section to talk about some ideas in general. some of the things that Chris and I are thinking about now when we think about this area, what we think about compliance in the future. And so we just wanted to get a feel from the audience in a way. We just wanted to see what you guys thought about some of the securities laws and compliance for these various tokens. So if you're going to do an ICO, for example, how many countries do you have to be compliant in? Sure. So that's a good place to start, right? So if you're thinking through this type of issue, how would you, so if you're going to run it?
Well, I'd start by banning the US for starters.
Okay.
Okay.
And then everything that's roughly in the same regulations, because you can see always when they do ICOs, or even STOs for that matter, you just go, there's a whole bucket list of countries that are not allowed to be using that. And I think the list is getting smaller, but it's there.
Mm-hmm.
And until these countries adapt, that's going to be the way it is, or they're accredited investors, and then apparently anything goes.
Yeah.
Right.
Perfect. So, I mean, that's a great answer. A lot of times people start giving numbers. There's a little bit of a trick question, but two ways of thinking about this are, where are your investors and where do you want to run the token? So which countries will the token be available in? And so you can count up those jurisdictions and get a rough idea of where you need to start with. So that's a general good rule of thumb. You start with two kinds of principles. Where are my investors and where will the token be used in? And so if you're going to do that and you want to keep the dream alive. So one of the things that Chris and I were talking about is the dream dead? Have security regulators killed the dream? I mean, the dream was you could come up with a token and raise funding globally. You can come up with something that's available to every single person in the world. Is this dead? If you do that, how many countries do you have to be compliant in? I mean, it's an open question right now, but I don't know if anyone has any thoughts on that.
They're kind of napping right now. It's not really dead. It's not really a dream. It's just the in-between phase where everybody's just seeing and waiting what the other is going to do. But they are tokenizing stuff all over the place. I mean, for the moment, like I said, the New York thing was a building, which is only accredited investors. But I think it's not going to last. But that's just my opinion, right? I mean,
Right.
I think people are going to want to get in, and they will be able to get in in some form or another. I mean, if the Chinese want to watch American internet, they use an FTP. Well, it's the same thing. They'll use, I don't know, crypto FTP equivalents. People will be able to get in one form or another.
Right.
Right. And so Chris and I have been thinking about this from a legal perspective, about how we keep the dream alive. How can crypto be made available to everyone? How do you do that in a legally compliant way? And so we've thought about these questions, and we've thought about some of the answers we usually get. And I've kind of put them into three buckets: the 1-year solution, the 10-year solution, and the 20-year solution to keeping the dream alive. And so the 1-year solution, I mean, what we hear a lot of times when we're going around and speaking is they line a lot of lawyers up on a panel. They're from a lot of different jurisdictions, but usually it's the US, Malta, Switzerland, Gibraltar or UK, and maybe Estonia or a couple others.
Yeah.
And they have a jurisdictional death match. And one jurisdiction is trying to win over the other, and they say you should put your company here, you should comply with securities laws here, and you'll be great. And the basic thinking behind this is that if you come to Switzerland, for example, and you get your token qualified utility, you get a non-enforcement letter from FINMA, then you're doing great. You're compliant with laws, and it's good to go. The dream's alive. That's the first. That's 1-year solution. Because the thing is if you then if you start offering that token in the US, for example, and it's a security in the US, that's going to be a problem because you didn't try to comply with US securities laws. So I call that the 1-year solution. It's called comply with the jurisdiction that you're in. Comply with your home jurisdiction. So the SAFT, for example, is a 1 jurisdiction solution. It solves the problem in some cases, maybe in the United States. Double Ds are the same. So what's the 10-year solution? The 10-year solution is you spend a lot more on legal fees, but you comply with securities laws in relevant and important jurisdictions. So for example, you might comply in the US and Switzerland if you think that those are going to be your biggest audiences, if that's where your investors are. Or if you have a little bit more to spend on legal, you might try the US, Singapore, and Switzerland. So you try to hit some key jurisdictions. You might try and hit some of the jurisdictions that are more regulation focused.
Peter, why are you not mentioning some other, I mean, we're talking about 10 years, right?
Yeah.
So is there a reason why you're not mentioning places like Malta, Gibraltar?
So, no, they could all be on here. They could all be on here. The reason that I call this the 10-year solution is that last year we saw a lot of one-year solution. We saw a lot of people who just wanted to come in quick, make some money. Now, as you see the tide go down, you see this appetite for STOs come up a bit. You see more people that are thinking about this and actually willing to spend money on the kind of legal compliance that they need to hit the hot jurisdictions. So you think about the ones that have enforcement actions out, the ones that have regulators with their eyes turned to this. And that's sort of your 10-year solution. But I mean, that's still not the dream though. I mean, people don't sit back and think, gosh, I really need to be compliant in all these jurisdictions. And they think I want to create a token available to everybody. I want to lift, poor people in Africa. I want to reach people in Asia. I want to reach everybody. It should be a global token. So this solves some of the problems, but how do we keep that dream alive? So I've been thinking about this lately, and these are just my thoughts. You can call them, you can call them out. You can say whatever you want, but my 20-year solution, which, I think could address this potentially, would be a token treaty. And basically with a token treaty, what you would have is, for example, Switzerland and Malta entering into a treaty where they have some sort of agreement, like a standardized form, about what a private placement memorandum should look like. So I would say most of these securities compliance for tokens so far have been creating a prospectus or a private placement memorandum, and that will comply with securities law in a lot of cases. So you have these treaties that lay out a standardized form that both countries have agreed on about what should be in a private placement memorandum. They agree that this should be the standard form. And you have, for example, a mechanism in each country where you can bring that to a regulator beforehand. The regulator approves or doesn't approve. But once, like a corporation in its home jurisdiction planning to offer tokens, goes to the regulator and gets approval, if it's in a treaty country, all the other treaty countries should recognize the decision made by that home jurisdiction. So that way you can create a network or a safe zone of countries that have signed into this treaty so that you can safely, once you've gone through this process in your home jurisdiction, offer this token and pull in from investors in every country that's had a treaty approved by it. So this is my pipe dream for keeping the dream of crypto alive. Go ahead, go for it.
An easy question for you, but what do you mean by non-enforcement letter? What is a non-enforcement?
Yeah, so I'm sorry. Yeah, we skipped over this. One of the important things of securities law in Switzerland is that you can actually go to FINMA beforehand and try and get your token pre-approved as one of the three types. And if they do that and they agree to it and you stick to what you're telling them, they will give you a non-enforcement letter, and it prevents FINMA from coming in down the road and basically taking control of your company if, you're violating securities law.
At the moment you said this is only applying in Switzerland?
Well, there's other jurisdictions I think that have something like that.
Yeah,
but Switzerland.
It's a pretty typical framework. Just Switzerland is probably the most defined at this point.
So, that's just one example. The treaty would have to cover a lot of different items, but this would be one method for having companies or people that want to, have a global token, letting them actually do that in a somewhat not so onerous way legally. Because right now, the alternative is you go to every single jurisdiction and you try and have compliance in that, and it is expensive.
Yeah, so who should drive those treaties? Like, is it the country? Is it the law firms?
Yeah, I'm thinking on that one. I guess.
To set up a crypto United Nations.
I think,
I mean,
consortium or something?
yeah, I think that's maybe where that starts. If you have ideas, that's why we're here. So.
Right. Well, and I think the idea is the regulators or the countries are going to do something. And so I think the idea is that the community engages them when they're starting to think about it, so you can help steer the conversation and help them frame what would be a workable treaty in a way that would help facilitate the growth of the platforms. And so we talked about 2017 was the year of the utility token. Everyone was saying, these are not securities, these are utility tokens that we don't have to register. That's not a problem. And then that became a problem. So 2018 is the year of the security token. And so just go ahead and register, and you'll avoid the problems of 2017. And then there's the concept of an airdrop. Well, we're just giving away these tokens. They're not securities. We're just giving things away. So we shouldn't have to register. So everyone's coming up with what they think are creative ways to stop the trend from that bridge of 2017 to 2018 from repeating. What Peter and I want to help facilitate is the creation of the GTO, which is the global token offering. And this is a token that can scale globally. So a lot of times when people talk about the technology, they want it to be scalable. So you create your platform, it works great, but there's scaling issues. And for whatever reason, you can't increase the user base if it's not set up correctly. You want it to be able to scale so it can grow at an appropriate speed. Well, we think of legal scalability in the same way. As you can set up your platform to be compliant in the jurisdiction where you had your ICO, and that works great for when you're raising the ICO just in that jurisdiction. But you have to think about the world. And if you think about it ahead of time, you can set up your token so that it can scale legally and it can reach its full potential. And so we have the four kind of general concepts that we think about. And Peter is the next.
Yeah, so
okay,
this could
ahead.
be the last one too, because I think we're way past 20. So at the beginning of this, I told you that this presentation was brought to you by the number 195. And I know you've all been thinking about that in the back of your minds this entire time. What is he talking about? 195. And so to lift the veil on the mystery, this is what it means. To have a fully compliant and truly global token, you should be compliant in 195 countries. This is what the number of countries registered with the UN. So it means if you want to be truly global, you have to comply with the securities laws in 195 different countries potentially. So this is what the challenge is. This is what we're trying to face. And hopefully with some creativity and some people who like token treaties, it's a challenge we can meet.
All right. Let's just close. I just want to thank Chris and Peter about the talk.
Thanks for coming.
So I believe the dream is on. I believe it too. So hopefully we have some dreamers in the room as well. So yeah, thank you again. This is our knowledge week, bi-weekly. So we're always looking for some interesting talks. So if you want to share with us something you are passionate about it, please talk to me, and so we can do something similar as well. Thank you.
Thanks for coming.